at this time.
All right.
To be honest.
Okay. Come on up.
Hi.
Hello.
Hi.
What's your name?
Rosa Banic.
Say again?
Rosa Banic.
Yeah, I know. All right.
I told you it's you.
I just said, make you say it again. Go ahead. What do you want to tell me?
I want to drop the no contact order because, as you know, we got 2 kids together.
This is where it gets complicated. Rosa isn't defending her ex's behavior. She's drawing a line between partner and parent. Despite the domestic violence charge, she's saying, "He's not good for me, but he's good for our kids." That's a powerful distinction, and a risky one. In domestic cases, courts often protect victims from themselves, because emotional reasoning can override safety instincts. What do you think? Is Rosa being brave or dangerously lenient?
My daughter's disabled. She has a severe speech delay, and his sister is not a good third-party person.
Wow.
She was sick. Yes. I'm sorry.
Okay.
As a person, I don't know why you wouldn't tell someone that you're giving your child meds, or even ask someone who works in the healthcare profession like I do about medication that a 4-year-old can have. She also has 5+ allergies, and they fail to acknowledge this. Okay. And it's just kind of disappointing to me. I thought she would be better than that. And I trust him more than I trust her. We just can't be around each other.
That wasn't a great endorsement, but
No,
I mean,
look, there's this domestic violence thing. He has his own issues, okay? He has mental health issues. He needs to fix that, and he needs to fix it without me, okay? And I trust him with the kids 100%. We just cannot be together.
Got it.
Yes, he's
Okay.
fine with the kids.
So you're looking, and probably we should let everybody know you've appeared before me
Mhm.
on another docket,
Yeah.
right? What it sounds like to me you're asking is for no contact as it regards to children.
The judge is clearly trying to tread carefully. Notice how he keeps circling back to no contact as it regards to the children. That's legal phrasing meant to define boundaries. It's not just about talking. It's about when, how, and under what supervision. Every word matters here because if contact happens outside court-approved terms, it can violate probation instantly. One slip and her ex could be back in custody. This isn't just a conversation, it's a legal minefield.
Yeah.
Is that?
Yeah. And if he gets inappropriate, I'll just block him and let him cool off.
Well, I just want to make sure that we're all on the same page regarding this.
Yeah.
Is there parenting time with reference to the kids that needs to be taken into account?
We don't have like a official custody order. I just give him the kids on the weekend because my daughter doesn't understand.
Pardon?
I
Say
said
again?
I give him the kids on the weekend because my kids don't understand. So his sister picks him up after work on Fridays because they don't have school on Fridays. And it's been really hard on my daughter. So I figured it was the best thing since she doesn't really understand what's going on.
Okay, so and during the week,
I have them because they go.
You have them full time. There's no. Okay.
Yeah, because they go to school out in Ann Arbor.
Got it.
Yeah.
Okay.
And Your Honor,
Yes.
prior to changing contact, this may be another issue. He's on.
Here's the key twist. He's still on probation for domestic violence. That means the no-contact order is not just a family court rule. It's a criminal condition. Even if Rosa wants it gone, the court's hands are tied. The probation officer's word carries weight here because any early contact could signal non-compliance. And when you hear dates like sentenced in January and offense in August, it shows how fresh this all is. The wounds, both emotional and legal, haven't even healed yet.
Probation, I believe, by the 15th for domestic violence, it would the same harm, and that might cause to contact as well. I believe the no contact order in that case is still in place and was in place at the time of this, so I would be objecting to any change of contact in this case as well.
Yes, ma'am.
I am in contact with his probation officer too, so
Well, just so that I'm clear, he's
eh,
been sentenced in that case,
Correct.
and as part of the sentence, there's a no contact probation.
I believe so.
Does anybody have an offense date on that case?
last year in September.
Mm-hmm. Maybe on this complaint, because this is charged as a second.
So the offense date was August 20th, 2024. He was sentenced on,
January 8th.
correct, Your Honor. And the conditions that were put in place on that case on 10/22 mirrored this case, so there is a no contact currently in place in that case.
Got it. You wanted to say something?
Oh, I was gonna go in front of the other judge too and just ask. I mean, I've already been in contact with his probation officer anyways.
Mr. Parody, you wanted to say something? Or?
Yeah, it looks like there's a review hearing on the 19th. There,
For their case.
for, yeah, the probation case.
All right. What I'm going to do then, what's my date after the 17th?
December 1st.
All right. So what I'm going to,
This is the court's version of a pause button. By adjourning the case to December, the judge is signaling, let's see what happens on probation first. It's cautious, procedural, and absolutely intentional. Judges often prefer consistency across court orders. No one wants conflicting rulings between probation and family matters. This adjournment isn't procrastination, it's legal choreography. He's letting the probation system decide before making his move. Smart? Maybe. But frustrating for a mother just trying to keep the peace.
do in this case is I'm going to adjourn this case instead of to the 17th to December 1st, 2025 at 1 p.m. I'm going to let, since he's on probation and would probably have a more intense look at him, I'm going to see what they're going to do with regard to the no contact. So at this juncture, Banic, I'm not going to change anything. I will tell you that given the timing, so that you understand where I'm coming from, given the timing of the previous case, the sentencing on the previous case, and then these charges.
And here's the emotional center of it all. I have some grave concerns, the judge says. That's judge speak for, I don't trust this situation yet. The court is protecting Rosa from potential relapse in the cycle of abuse, even if she insists she feels safe. It's an incredibly difficult balance, honoring her autonomy as a parent while preventing another possible outburst. The subtext? We're not saying no forever, but not yet. A cautious mercy wrapped in legal restraint.
I have some grave concerns about whether or not I'm going to allow contact. I understand why you're telling me that. I'm just going to have some concerns about what might lead to a too close a proximity for my feeling to you in this case. Okay. So I'm not saying no forever, but right now I'm not going to change it. All right. Thank you. All right. So this matter will be December 1st, 2025, 1 p.m.
Thank you. Thank you.
All right. Thank you. Bond will continue with its conditions. All right. Record should reflect we've had a brief bench conference in this case. I am going to adjourn this matter out to my next available date of November 17, 2025, 1 p.m. There may be, or there is going to be a request regarding contact until there's further discussion with the victim in the case. the court is not going to address this at this time. Also, we were unable to get a Bengali interpreter for today, so. All right. 17th at 1 p.m.
Thank you.
Thank you.
I'm gonna send you.
What we've just witnessed is a real-life tightrope walk between love, safety, and law. Rosa Banic wants communication for her kids' sake. The court wants protection for her safety. The judge adjourns the case, waiting for the probation court to make the next move. Until then, the no-contact order stands. It's a reminder that in justice, timing is everything. What's your take? Should co-parents in domestic cases ever be allowed supervised communication if both agree?